Good evening, aspirants. Welcome to the GET.SET.LA. Today, we are going to discuss the September part 2 of the important legal current affairs. So, let's get started. So, for the very first time, BCI has conferred the Vidhi Ratna Award, and they have selected 5 legal luminaries. And these are the 5 very top-notch personality from the advocate side, and they have been conferred with this award for the very first time. So the senior advocate K. Parasuran, Fali Nariman, A.K. Venugopal, Ram Jethmalani, and Soli Sorabji. So these are the 5 people who have received the award, and they have played an extraordinary role in the litigation journey for the last few 60, 70 years. So that is why they have been considered for this inaugural award. For example, K. Parasuran has served as an Advocate General of Tamil Nadu, and later during the Indira Gandhi government, he became the Solicitor General also. And he has served till the tenure of Rajiv Gandhi in 1989. Whereas Fali Nariman is considered as one of the most prominent and the historic constitutional lawyer, and he has led several cases which has of the very prime importance. And he also served as Additional Solicitor General during the 1975. Ram Jethmalani, whereas is considered as a very prominent criminal lawyer, and he was a politician too, and he held very significant posts during his time, and he served an illustrious career. He has numerous achievements and very big shot cases he has fought. He also served as a Union Minister of Law and Justice. He served as the chairman of Indian Bar Council and president of Supreme Court Bar Association. And Soli Sorabji had again a very prominent role to play. He was a senior advocate in the Bombay High Court, and later on he became Solicitor General of India from 1977 to 1980. And thereafter he appointed as the Attorney General of India, and he was there till 1990, and again picked up the role and served until 2004. So all these 5 people had a very prominent role to play in our whole history of litigation, and that's why they have been awarded. 2-day national consultation, the collaboration of Supreme Court and UNICEF. So Supreme Court Committee, the very specialized committee on the juvenile justice and child welfare, they in partnership with the UNICEF India, they are organizing a 2-day national consultation on best practices. So it was followed in the states and the way forward, so that they can decide how they can improvise the justice system for those children who are in conflict with the law. So we have found this issue that there are a group of children who are in conflict with the law and they face a lot of issues. So that is why this will be a very good step where we can provide justice to these people. The inaugural session, which has been conducted by the court, will be graced by the Smriti Irani, Minister of Women and Child Development, Justice Ravindra Bhatt, Judge and Chairperson of the Juvenile Justice Committee, Supreme Court. Then Justice B.V. Nagaratna, he is a Judge of Supreme Court, and Mrs. Cynthia McCaffrey, she is a representative of UNICEF India. So these were the prominent dignitaries who were the part of this 2-day national consultation, and they will decide the matters in which they have to take a very crucial decision with respect to the juvenile justice. Then this was the year which marked the 8th round of national consultation. So Juvenile Justice and Welfare Committee conducts this every year, and under their ages this was proved to be the 8th round. Now, this year they had a special focus on the children in conflict with law, prevention, restorative justice, diversion, and alternatives to detention. So, as we all know, that Article 22 talks about the protection against the illegal detention, and somehow we all have a fundamental right, and the court had the concern that some way or the other we should avoid the detention, and that is why we want to avoid it. Then next is Sri Krishna Janmabhoomi and Shahi Idgah Masjid dispute. So this dispute was very well anticipated because of the previous 2 cases in this regard, which was started by the Ram Mandir and this Ayodhya and Babri Masjid issue, which was was started back in 1991 and it had its roots from earlier 1800. So the concern was that the Ram Mandir has been the 2.5-acre place has been taken over by the masjid, and thereafter the dispute started. People destroyed the Babri Masjid, and there how the litigation started. On a very similar note, we had a discussion on the Gyan Vapi Mosque versus Kashi Vishwanath Temple, where again it has been believed that the original Kashi Vishwanath Temple has been replaced by the Mughal rulers by constructing this Gyan Vapi Mosque. And very recently, the Supreme Court has conducted in the last month. We have also discussed in this series that the last month Supreme Court ordered for the scientific survey by the Archaeological Survey of India in the Gyan Vapi without doing any kind of excavations. And now this is going to be the third case in the series, which was very much anticipated because these were the three prominent temple mosque issues in our country, and all of this lies in Uttar Pradesh itself. So now in this case, Supreme Court has refused to entertain that they will not take up this plea, which has been filed by the Sri Krishna Janmabhoomi Mukti Nirman Trust, and they want to again seek a scientific survey as had been done before also. So the court has denied that they will not do, and the court has said that all of these matters will be dealt by the Allahabad High Court. So they have left it open to be decided by the Allahabad High Court, and because that is the first point of contact for this particular petition, so it will be better that they will do it. So the very brief history of this is that Shahi Idgah Mosque, which was built on the orders of the Mughal Emperor Aurangzeb. So when they made it very adjacent to the Krishna Janmabhoomi temple, and it is of the prominent belief that the Lord Krishna has taken birth over there. So in 1968, post-independence, when even during the independence, during the division of Indian Pakistan, it had a very big concern with respect to the Ram Mandir case. And since already, which is the Lord Krishna has taken birth over here, so this place was very much close to the people from the Hindu community, and they had the discussion. And later on in 1968, they signed an agreement which was known as a compromise agreement. So this was done by the Sri Krishna Janamsthan Seva Sansthan Committee, and which is the temple management authority. And on the other side, there was Trust Shahi Masjid Idgah. So these two trusts came forward and they signed an agreement that both of places shall function simultaneously. It will operate simultaneously, and there will be no clashes from the groups because there is a mutual understanding now that our property is different and their property is different. Although it is on the same boundary line, it's the same boundary line which will distinguish both the areas. So this was the agreement which has been signed by both the communities. However, litigants thought later that this is the kind of agreement which they have made in 1968 is not correct, and that is why they want to overturn that agreement, considering that it has been signed by the trust in force and this is invalid in law, and that is why they want to retake the matter and to be decided by the court via scientific survey. Supreme Court constitutes 7-judge bench. So Supreme Court has constituted a 7-judge bench to hear the reference of the judgment in P.V. Narasimha Rao versus State, which was a very prominent judgment back in 1998. So one of the important judgment of P.V. Narasimha Rao was they decided that legislator enjoyed immunity from prosecution in cases of bribery. So whenever there is a case of bribery with respect to the parliamentary vote and speech, which they have got under Article 105 subclause 2 in the union level and in the state level under Article 194 subclause 2 of the Indian Constitution. Supreme Court has constituted a 7-judge bench thereafter to hear the reference of the judgment, that what is the specific issue with the petitioners are trying to raise right now. So why this is important? Because parliamentary privileges have been given under Article 105, which gives a lot of immunity and privilege to the legislators with respect to the prosecution in the civil and the criminal matters. So they have said that this is going to be a very important one, because the question is with respect to the immunity and the sovereignty enjoyed by the parliamentarians. So there is the seven judge bench, and seven forming a seven judge bench had been, according to the previous record, in a very special cases. So this is going to be the one where the rights and the limits of the immunity will be decided by the court. And the bench comprises, they released a bench of the judges who are going to be sit in the seven judge case. So it is headed by the CJI DY Chandrachud, Justice AS Bopanna, Justice MM Sundaresh, Justice PS Narasimha, Justice JB Pardiwala, Justice Sanjay Kumar, and Justice Manoj Mishra. So these are the people who are going to be there in the bench. And it is one of the important concern that although they have the liberty to, they must be free to express their views on the floor whenever there is a discussion, like we had a discussion in women reservation bill for 12 hours straight, from morning 11 to night 11, right? So that is the concern, that to what extent the parliamentarians can enjoy their immunity. This will be decided by the seven judges bench. Now, lastly, we have women reservation bill, which is very, 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 very important. And this bill has been previously attempted in 2008, where it has got lapsed. And finally, in 2023, again, we have passed this bill, and it got passed by Rajya Sabha on September 21st. So they have passed unanimously, whereas we saw that in Lok Sabha, the majority was 454:2. So because we needed a special majority, we got 2/3 majority of the members who are present in the voting, and they introduced this 33% reservation for women in the lower house in both the state legislatures and the Legislative Assembly of Delhi. So Delhi Legislative Assembly covers under Article 239 AA, because it has got the very special status. The constitutional status has been given that Delhi is the only UT which has got the form of state. So that is why all the state legislatures are uniform. They practice uniformly, whereas Delhi has got the status in a special form. Then the concern is that the application or the implementation of the reservation bill will not be done immediately, because of the issue that we need to practice delimitation exercise. Now, what is delimitation exercise? Delimitation plays a very important role, where we have to reconsider the constitutional territories. So we have to see the constituencies, how many constituency one state have, and basically the constituencies decided as per the population. As we all know, that there is a census in every 10 years, which has happened in 2001, then 2011, and then it was supposed to happen in 2021, but it did not happen. So it did not happen in 2021 because of the COVID, but it should happen in 2031, but the government has decided to conduct in 2026. So they have decided that after the general elections in 2024, they will conduct this election, as it got postponed because of the COVID. So thereafter, by 2029, which is the next general election, next to next, so they will be able to implement the women reservation bill, because by that time we will have a proper course of delimitation, and the constituencies will be decided, seats will be increased, so that more women will be given an opportunity. So this bill was presented as a 128th amendment, constitutional amendment, and that is how it came into the Lok Sabha, and Lok Sabha passed, and it went to Rajya Sabha, and it is passed from there as well. So this was all for today. Thank you for joining. Stay tuned, and I will see you in the next video.